So, good morning, everyone. Today, our guest speaker, Oliver Oguz, from Trademark Wizards, will be discussing critical importance of brand protection. Over to you, Oliver.
Thank you very much, Max. That was a very generous introduction. I'll take all those compliments. Thank you. Nice to meet everyone. And thanks for your time today. And obviously, Max, thanks for the invitation. That was very kind of you to have me on here. Um, I guess first of all, I'll share my screen with everyone. Morning, everyone. So my name's Oliver Oguz, and I am a chartered trademark attorney, chartered trademark and design attorney. So ultimately, I protect brands for businesses. Um, I used to be an EU trademark attorney, but since Brexit, I lost all the EU rights, and therefore I only practice in the UK. But we do deal with trademarks globally using representatives in trusted representatives through our global network. So I started Trademark Wizards in 2012. And when I started Trademark Wizards, we became the UK's #1 trademark filer. We're not a firm of solicitors, so we only specialize in intellectual property, design and copyright law. We do confidential information and cyber law, but ultimately, predominantly it is what it says on the tin. We do trademark work as most of our work. We usually advise on over, I would say, 5,000 to 10,000 branding elements for clients every year. We've got a small team, but we move really quickly, and we do get a lot of inquiries coming in. And we are one of the highest trademark filers in the UK, for sure. And we have clients from startups all the way to to big corporate giants. Ultimately, everyone with a business has a trademark, and they should really protect it. In 2021, when we did become the #1 trademark filer, we got some backing from Lord Sugar. So Lord Sugar is my business partner, basically. So we run the company together. Well, I do all the work with my team, and he helps with profit sharing, etc. But his team run all the back end, and we focus on doing all the legal work. So ultimately, what I do is I protect intellectual property. So that's any property that's created from the brain. So you have trademarks, which is the brand. You have copyright, which is your artistic, musical, literary work, sound recordings, etc. We do designs as well. So if you have products, we can protect the appearance of the products. We don't do patents because we're not patent attorneys, but patents are types of intellectual property that protect inventions. And then we've got domain names as well. They are sort of quasi IP rights as well that should be protected. And then anything that can't be protected by the above gets protected via confidential information, such as recipes, the Coca-Cola recipe or the KFC recipe, whatever it is. But the main focus of today is going to be on trademarks. So let's start off with what I'll just give you a whistle-stop tour of this, which usually takes me about 2 hours, but I'm going to steam through it in 20 minutes. Trademarks are, and by the way, you don't need to, if you just want to focus on the presentation, you won't need to take any notes because I'm happy to. I've got my team here, and if anyone's got some questions, I'll leave my details, and we can always send you advice if you need advice on trademark protection and searching, etc. So feel free to send us an email after. But a trademark is a sign. It used to be a sign, any sign that's used in business that represents the business, and that's used to distinguish your goods and services from other people's goods and services. So one trader from another trader, if you will. A bit of useless advice for you, a bit of useless knowledge for the dinner party, is that trademarks used to have to be represented graphically, but now they don't. So that allows room for unconventional trademarks like potentially smells to be protected by trademarks, although they're very difficult to protect. They're quite unconventional. These are the signs that you usually see next to a brand. We'll start off with the C. The C represents copyright, so that's why you usually see it on album covers or websites to protect the literary work or the typographical arrangement of stuff. It also protects coding if you have websites and you have apps and stuff like that. The R in a circle protects the trademark. So once the trademark's registered, you put the R in a circle there. Be proud that the trademark's protected and let everyone know when they see that next to your branding. They should know not to mess about with you, otherwise they're going to get sued. And the TM is usually used when people don't have trademarks. Sometimes trademarks are descriptive, so you need to put the TM next to it to show people that it is being used as a trademark. We don't usually advise people to put a TM next to their brand because ultimately you're just telling everyone you don't have a trademark and someone else can end up just nicking it, which happens day in, day out. We get at least 10 a day coming through our door. These are the different types of trademarks that you have. The ones it shouldn't be, I shouldn't have put it as easy and or difficult. It's conventional and unconventional. The ones on the left are the ones that you would usually find. So words, pictures, logos, etc. They're the most common ones because they form your branding elements. And the unconventional or more difficult ones to register are colors, sounds, etc. Because these trademarks are very difficult to describe in a trademark application. And also with colors, very difficult to register colors because you have to prove that it's acquired a distinctive character, like the Nestle. What was it, Nestle? Um, I think the chocolate brand Cadbury's, and they've registered the color purple somehow, but everyone associates purple for chocolates with Cadbury's. Um, when you protect a trademark, you have to protect it in relation to different categories of goods and services, and they're grouped into things called classes. These are there are 45 classes in the whole international registration system, and it's all uniform around the world mostly. And this is just an example of it. This is a tech company here, so they've protected software, they've protected advertising, they've protected communication and broadcasting, telecommunication services. They also protect content creation as well as the platform itself and online social networking services. If anyone here needs some advice on what to protect, or if you've got clients that you need to advise on trademark related matters, you can just send an email in just telling us what type of business it is, and we can just send you a list of classes that to help you make a decision as to what to do when you're protecting the brand. It's in terms of the money, this is always the important bit because this effectively dictates the decision as to whether to go ahead with it. People think that trademark protection is a kind of rich man's sport, if you will, because they're used to seeing the R in a circle next to the big brands. But actually, a trademark only costs £170 for one application in one class. Well, I say only, it's not my money, but I mean, in the grand scheme of things, £170. The trademark lasts for 10 years, so you're paying £17 a year to effectively insure your brand, which is the most important asset of your business, apart from yourself, obviously. And you can also have an EU trademark as well. It's one trademark that covers the whole of the EU, so it covers all 27 member states now. It used to be 28, but we don't talk about that anymore. um, and that's it, and that's 850 euros. So if you do the maths there, you can see the value that you get for 27 countries being protected. This is the, I guess, part of the anatomy of a trademark registration. So you have the trademark number, you have the status, which is the status is registered here. You'll be able to find the list of goods and services and who owns the trademark and who is represented, who represents the trademark owner in terms of which law firm. And then obviously you have the actual graphical representation under trademark. And then you have the dates. These are the important dates to remember. The date it was filed, because that's when your rights start. The date it was actually registered, which should usually be shortly after the filing date if there's no problems, a few months after. And then you definitely need to remember the renewal date, because if you miss that, then your trademark's gone and it's usually fair game and up for grabs. So it's always good to have some professional representation with your trademark because you'll get renewal reminders. You'll get you'll get the team representing you, badgering you to renew the mark. So yeah, sometimes people inadvertently miss that deadline, and that's it. The brand is gone. The company is devalued significantly, and then someone else hijacks the mark, and other people come onto the market using the mark. Happens every day. I'm not sure how well this is going to work. You guys are going to be my guinea pigs for this one. It's a bit of animation there, courtesy of our Helena, who's on here. I'm not going to take the credit for this, but when you protect a trademark, it's just an example, really. So let's say somebody in London, let's call him Max, because I've spoken to Max and his name's in my head. I can see it there. So Max has set up a chicken shop in London, okay, and I'm sure the food's really good at Max's chicken shop restaurant. And then you can see a chap up north. I'm assuming that is Scotland, although my geography didn't get a good mark for geography for my GCSE. And our Scottish chap has visited Max's chicken shop. He's gone up to Scotland and thought, I can do this over there. And then all of a sudden, our Scottish friend has started franchising the business. He's opening up chicken shops everywhere, and he's actually swamped Max here. And the only thing that Max can do here is, I guess, if he doesn't have a trademark registration, that's the end of Max's business. But if Max does have a trademark registration, it's effective all over the UK. It's a national right. So you can just start zapping everyone and collecting your money because all that money is Max's money. So therefore, that is the power of the trademark registration. Um, in terms of the EU trademark covers all of the member states of the EU, and the UK trademark will not be effective in the EU. And so someone could pop over from, I'm just going to say Germany. I know I'm wrong, but there's someone's going to pop over from Germany or Poland or wherever that is, and they can nick the idea, and Max effectively will not be able to do anything unless he has that EU trademark. And then what he could find is all over the EU, people are using his brand. So that's not a position that anyone wants to be in. But the same analogy applies whether you're selling services, products, it doesn't, and services as well. I think this is probably one of the most important take homes today. So focus on this one. So when you file your first application, which essentially could be your UK application, you're protected all around the world for 6 months. It's called the priority period. So if somebody files a trademark in another country, um, let's say you filed your UK trademark on the 1st of January, and Max has hijacked it, and he's filed your trademark in different countries around the world. Let's say he's filed it in the EU on the 1st of March, so he's blocked you in the EU. But as long as you meet that deadline and you file your EU trademark before the 1st of June, which is 6 months, your EU trademark will take the UK filing date, and you'll be able to knock out Max's mark. But if you miss that deadline, then Max will own your brand in the EU. So be very careful about that. Um, on the flip side of that, you need to be careful. I'll give you one example. So, if you have a factory in China, for example, you could be giving them your manufacturing work, and sometimes the Chinese factory will register the trademark. But this could happen anywhere, but mostly at the moment it's in China. So, let's say they've registered your trademark and you don't know about it. You could do an EU trademark search and file your trademark in the EU because the trademark search has been clear. But then once you've grown the business and filed the mark, your Chinese factory could file an EU trademark, knock out your EU trademark, and just leverage you and steal your brand. That happens day in, day out as well. So if you do decide to do a trademark application, always do a global search because someone could have taken it in another country and they can leverage you with the priority. I hope that was clear because that was so very important. If you only remember one thing out of this conversation, that's what you want to remember. And then I guess the value of protecting the trademark, we're going on here to international trademark protection. So if you file there's no magic trademark that covers the whole world. Otherwise, my life would be so much more easier. So you have to trademarks the jurisdictional rights. So you have to protect a trademark in each individual territory to have protection in that territory. Now, there's something called an international registration, okay, which is essentially a filing cabinet for trademarks. So you can actually file something called an international registration. It's a bit misleading because it's only a filing cabinet. And in order to do that, you have to have something called a base application. And you can use an EU trademark as a base. However, we never advise it. And I'll give you an example here. So Max is in Germany and he has a German trademark. So he can effectively attack your EU base with his German trademark. It doesn't even have to be identical, it can be similar. And when Max does that, your whole international trademark dies. It's called a central attack. And then again, your trademark is then up for grabs by everyone who's waiting in line for this to happen. Sometimes it's a very sophisticated operation where you could be targeted. Um, Ultimately, if you do have an international mark, you should always use a national mark as a base, not an EU one. And then what would happen here in the same scenario if Max wanted to attack the EU trademark? He would attack the EU trademark down there, basically, at the bottom. So everything else would stay intact with the EU. So you could still have the fight, but it wouldn't affect the rest of your EU, your international trademark registration. So that's a very important. It's always important to have a strategy in place. So if you don't have a trademark, these are the things that are probably going to happen to you. Okay. So, your brand will be hijacked. Someone else will file that trademark for you and effectively hold you hostage over your own business. Worst situation you could be in as a business owner because effectively you would have to buy that trademark from them if you or fight them for it, um, and it all costs money. And also, as well, if you don't own your trademark registration, your trademark can be diluted. So everyone can start using it and it will just lose its distinctiveness. Um, you'd have to rely, if you did want to stop someone using the brand, you'd have to rely on unregistered rights. They're called passing off rights, but it carries quite a high evidential burden because you have to prove goodwill, you have to prove misrepresentation, and you have to prove a likelihood of damage over the brand. And if you do that because of the evidential burden, you can easily be looking at between 50K to 100K, when you could have just spent 170 quid at the UK Intellectual Property Office and you wouldn't have these problems. So we bear that in mind as well. A lot of people don't think about registering trademarks until something like that happens. And then they ask me what to do. And I have to, be the bearer of bad news, if you will. If you don't register a trademark, I'll give you some examples of things that have happened to our clients. So we've had clients that have had to rebrand during funding rounds, when they're getting investments, because the investors have said, "Where's the trademark?" and they the founders realize someone else has stolen it. And then they've had to rebrand. Very embarrassing, and you lose confidence of your investors. We've had recently a company whose family business has been going since the 1800s, going through generations, never registered the trademark, came to us and found out that everyone apart from them has been registering their trademarks in different classes, and to clear up that trademark register and take action against everyone is not a fun exercise as a business owner. And so it's essentially, most of our clients are not the big giant corporates. We usually are defending our clients against these big companies that sometimes effectively abuse their IP rights. So our most recent wins this year and last year are against McDonald's, Pinterest, Armani, eBay. There's probably some more as well. There's probably a few more. So we're starting to write content on our website about this. If you want to see a bit more about what we do, we have an anti-bullying program as well to help the smaller businesses if you are genuinely being bullied. So bear that in mind as well. Don't be scared if you get a letter from a big company. They're trying to have a pop at you. Um, in terms of the benefits and the power of having the trademark, you can stop someone using an identical mark for identical goods and services. It's called double identity. There's no need to prove confusion, because if the marks and the goods or services are identical, then the junior mark automatically cannot be trusted. If the marks are not identical but similar, or if the goods and services are not identical but similar or related, if you can prove that there's going to be some confusion in the marketplace, then you'll be able to stop the junior mark from being registered, and you'll be able to take enforcement action against them. Um, and also, as well, if your trademark has a reputation, you can stop people using a similar mark in relation to goods that are not even connected with you, dissimilar goods. So you can do all of that ultimately for your £170 government fee. Also, as well, this is the best bit that people love: the benefits and the power of having a trademark registration. There's a special court. It's called the Intellectual Property Enterprise Court. IPEC is the acronym. So we call it the IPEC in our office, and it just deals with trademark disputes, trademarks, copyrights, IP rights in general. And if you have a trademark and someone's using it without your permission, the first thing you can do is get an injunction against them, so you can stop them using the brand. Sometimes that's the most important thing, to get someone to stop, especially if you're selling food, for example, or you've got a restaurant and you just can't have someone using the same trademark or a similar one, because we've had cases where people have used trademarks for restaurants, and that restaurant has had a rat infestation or some vermin infestation, and it's been shut down by the local council. And our client's restaurant has been affected on their reputation because they think the restaurants are connected. So sometimes you can just get the trademark. You can get the junior owner to stop using the brand first. You can also seize their assets as well that have the branding on it. So you can get transfer of domain names, social media handles, which is a massive hit. We've had people handing over the keys to handles with hundreds of thousands of followers. People handing over the keys to their domain names. It's a very powerful asset to have the registration, and you're allowed to claim up to £500,000 in damages from the person that's infringing or the company that's infringing. So ultimately, that's how the conversation, and you can claim your legal fees as well. So ultimately, the letter essentially says you're using my client's trademark. Here's a copy of it. We want all of these damages. We've seen your accounts on company's house. Here's my client's bank details. 14 days. Thank you very much. And that's how the conversation begins. So it's always good to have the trademark registration in your back pocket. Um, it provides you with maximum leverage in a commercial negotiation. And so, in terms of tips for protecting yourself, if you're based in the UK, always start with a UK trademark. It's quick and cheap to register. You get your global 6-month priority rights, so that gives you space to breathe. Um, Always conduct searches of national EU registers of the individual member states if you're filing an EU trademark. As I said, you could have a trademark in Germany that's similar, and that could knock out your whole EU trademark. So it's always good to do a national search. And here as well, I'll never use your EU trademark as a base for the reasons I've just said. Um, In terms of maintaining the trademark and enforcing it, as I said, it's 10 years generally from filing, from the filing date, not the registration date. If a trademark is over 5 years old, it can be cancelled for non-use. So make sure you're using the trademark as it's registered. So if you rebrand your logo, make sure you refile your logo, and don't rely on the old one for protection. Have a monitoring service in place. Your trademark attorneys will probably, put you on a subscription. So if anyone does file an identical or similar mark to yours, you'll know about it straight away, and you can sort of take action early against them. Because if you zap them early, they're less likely to have an appetite to defend themselves, and they'll probably rebrand. Make sure when you see someone with a conflicting trademark, always challenge them immediately. Don't give them any room to maneuver or build up a war chest using your brand, or build up a reputation, because then again they'll have more of an appetite to defend themselves. Um, and here as well, if you see someone using your trademark, don't let it become a generic word, because then you could lose the trademark for your inactivity of enforcement. So it's like people using Google as a verb now. Instead of saying I'll search it, they say I'll Google it. But they could now Google has become a general term for the word search, or Hoover, for example, or paracetamol, or whatever it is, escalator. These are all brands that have now become generic words and almost there now. These are the ways you can exploit your trademark and make money from it. So you can use the trademark yourself, self-exploitation. You can buy it and sell it because it's property. So you can also license it as well. Um, if you have your trademark registered for many classes, you can license the different classes out to people, and they pay you premiums and royalties for it. You can mortgage it, you can put it up for collateral. So if you want money from the bank, you can say to the bank, my trademark's worth £500,000. Can you lend me £500,000? And they'll put a charge against the trademark, just like they would against the house. And finally, if you get hit by a bus one day, or hope touch wood, no one will, you can leave the trademark as you would leave a house to somebody in your will. So if the inevitable happens, you have a registered right. Whereas if you don't have a trademark and something happens to you, what are you going to transfer? How can you transfer the brand or the business to your loved ones? And I think this is just the anatomy of a brand. So, for example, our brand, Trademark Wizards, we would protect the word mark. Trademark Wizards provides the strongest protection for the brand. You can also protect the stylized font here. So we've got the pink um, the pink dot on the eye, which was what I came up with. Uh, no one likes it apart from me, but yeah, I had the final say on that before we rolled the brand out. So we have to protect our stylized font. We also have a device here which we use as well. We protect that independently, and then we also protect the composite mark, which is all the branding elements as a whole. And thank you very much, ladies and gentlemen. So that's a whistle-stop tour of trademarks. I hope it was helpful, and I hope I explained everything as clearly as I could.
Wow. Thank you very much, Oliver. Thank you. Uh, shall I start out the questions? Yeah. So I was really, really interested in what you had to say. Just was wondering what you meant by self-exploitation. Is that just using the trademark yourself, or is there something
Exactly.
more?
So if you register the trademark for food, you could, if your trademark was Max and you had it
Mm-hmm.
protected for food and drinks, you could actually bring out your own brand called Max, and use the trademark yourself, rather than license it. It's like it's like having a house. You can
Yeah.
live in it yourself, or you can rent it.
Mm-hmm. Wow.
Yeah,
Okay. I understand that.
yeah.
Great. Um, anyone else? Oh yes, Spencer.
Hi, thanks, Max, and thanks, Oliver. That's interesting stuff. I've got some marks registered, like you've shown there, actually, sort of words and what you called the device. Don't know what I called that on mine, but and then the sort of the full sort of logos. Is there any way to be alerted by uh, the trademark sort of registration bodies, if people are making applications?
Yeah.
You mentioned that, the attorney that dealt with the ones I've got would be sort of looking out for that. But is there any way that I can still go to these places and actually put in alerts and things to find out what's going on?
Yeah, you could. I can even just give you a quick example. It will take me 2 seconds. But I mean, you could go to the UK intellectual property website and just type the brand in if you're looking for a UK trademark. You
Yeah,
could also, what else could you do? You could go into the WIPO website, WIPO, the World Intellectual Property Organization.
yeah,
If somebody files a conflicting trademark in the UK and it's identical, generally the UK IPO will, oh, sorry, generally the UK IPO will, sorry, everyone knows what I'm having for dinner tonight. Generally, the UK Intellectual Property Office will tell you about the trademark, but you shouldn't rely on them because it would depend on the examiner and how strict he is. So if you just give me one of your brands, Spencer, what's it called?
FD Pack,
FD, how do you spell it?
Pack, PACK.
PACK. Is it one
Yeah,
word?
one word. Yeah,
There you go. Oh, look, someone in China. So you can see here, FD Pack, FD Pack.
that's mine.
You can have a look at all the trademarks that you own here. So obviously we have very sophisticated AI here that pulls out live trademark data from all over the world. So with FD Pack, I can see here, look, someone did file in the US, in New Hampshire a while ago. I can look at it by application date order. So as soon as you that someone's filed an FD Green Pack in Turkey, since you filed your FD pack, someone in China has filed FD Snacks multi-pack, but that could be just a coincidence. Okay.
And that's available to me, is it?
No,
that
we
works.
only have
No, that's right.
this
Okay.
software. But if you want to
Right.
do us, if you ever want to run a search, I mean, you can see that what tools we have. So you can always send me an email or send me a WhatsApp, and then just say, look, can you just run a quick search on this? It takes me 2 seconds,
Yeah.
and I can get that answer for you quickly, so you can make a decision.
But would all attorneys have some sort of software to monitor their clients' marks?
Most of them should. I mean, well, no, I
Sure.
guess the smaller firms might not,
Yeah.
because we have to subscribe to it. And this particular software has just been taken over by the market leader in trademark searching. And so they've hiked up the price of this tool. They basically bought a competitor that was eating into their market share. But generally, the larger firms would have something like this, even maybe even more sophisticated. But generally, the larger firms would tend to charge, for this service, and they, I assume some of them might not be cheap, if you will.
Yeah.
But yeah, but yeah, notwithstanding that, there are much lower cost tools out there at the moment, and there could be some firms that subscribe to those as well. But this one's very user friendly for us, and we use it in litigation when we're fighting for trademarks around the world. We can see where people are filing their marks.
Mm-hmm. So that's and just to before Peter gets in as well, that's everything to do with FD Pack globally, is it, that we've shown on the screen there?
So here, this is your trademark portfolio in the name of small biz. Okay.
Yeah.
So
But all the other search results, is that literally it globally?
yeah, I mean, this is for FD Pack, but then obviously if I take out the C, oops, there's still I mean, if I look at all marks containing FD, there are no fewer than 7,000
Yeah.
marks filed globally. But then if I do refined, I mean, you look like you're only in the UK,
Mhm.
or focused in the UK. So if I
Yeah.
move them just to the UK region, then the results significantly
Mm.
reduce. And then I can also refine it by category as well. So if it's class 31, for example, then I can see all the FD marks in class 31.
Got it. Okay. Interesting stuff. Thank you.
No worries.
Thank you. Peter?
Hi, thanks, Oliver. It's very interesting presentation there. My thoughts are that the government has taken the route that intellectual property is not protected if AI bots or AI systems want to use them to practice on. How does that work with trademarks? Because obviously some AI systems may well come across those.
Yeah, I mean, people are using AI for everything now, and sometimes people don't even, I mean, graphic designers are becoming a bit redundant now as well, because people will just go into ChatGPT and say, I want a logo with a picture of an elephant, and this font with these colors in there. Can you give me one? And then so ChatGPT will give you the trademark. And I guess if you've prompted it, then potentially you can say, you wouldn't be sued by anyone for copyright infringement because it's ChatGPT that made it for you, and potentially some people potentially do claim ownership of the copyright because they put the prompt in there. It's yeah, the whole AI stuff, and IP and enforcement it's a very new area, but we haven't come across anything like that, because, as you say, the AI can't own the property, because in order to own property in the United Kingdom, you have to be a legal or natural person, so either an entity, a company, which has been incorporated, or a person. You can own it in your personal name.
Thank you.
Well,
Can I ask a question?
of course.
Oliver, thanks for all of this. Can you clarify how we protect our trademark in China? So you mentioned that they can take hold. Is that via having an EU registration, or do we need a specific Chinese registration?
You'd need a Chinese trademark for that. So what you would do is, if you haven't filed the brand already, what you could do is you could file it in the UK first, and
Yeah.
that would protect you in China. Okay.
Oh, well, okay,
Months.
so
So
I mean,
you would have 6 months to breathe,
okay, so
and then
we have a UK trademark that was registered January 24.
do you want me to have a look at it?
Sure, yeah, Mighty
What
Eve.
is it?
Mighty Eve Limited.
Okay,
So,
this is interesting.
oh,
So
okay, yeah.
don't
So
get scared. Okay, fine.
we're
So
on the
here you
list.
go.
That's our logo mark. We're
Yeah.
in the process of getting our word mark done right now as well.
Yeah. Okay, so here, Mighty Eve, it was registered in the US, but that US registration is expired. But they might be using it without a registration. But there's no one around the world that has Mighty Eve, that has registered the trademark for Mighty Eve. Your trademark was applied for in 2023, so your priority period has expired. Okay.
Yeah.
So what I would suggest you do is file the trademark. At the moment, you have your logo mark registered.
That's right. We're getting our word mark done now.
Yeah, so you need to get the logo, the word mark registered. When you file the word mark, you'll be protected all over the world for 6 months, including China.
Okay.
So you could wait for the word mark to go through, and then file an international mark designating China and claiming the priority from the UK filing date.
Okay.
Or you could just do it straight off the bat and file your word mark and file the international mark at the same time, because ultimately you've already got your logo that's gone through without challenge. So you could take a calculated risk to say that no one would challenge your word mark as well.
Okay, all right. So the reason for not doing the international mark off of the EU one, so just to try and understand what you were saying, is because if somebody else has already applied for it, then it just flags to them that you're doing
So
that.
if you if you use your EU mark as a base for an international mark, if somebody had a trademark in, I'm just going to example, not even an identical trademark, but a similar trademark in, say, Hungary, for example, they could use that as a basis to oppose your EU trademark. And because the EU trademark is a base, it's called a central attack, and your foundation for the whole international filing project is attacked, and it will die, and your whole and you would lose all the different countries that you've designated. So and I've had that before a few times. We've got a few on the go at the moment. It's not good for someone to have that leverage over you, because this cafe in Hungary or whatever it is that's attacking you would be able to say to you, well, pay me and I'll lift the opposition against you. And they would put a number down that they probably slightly less than what you would end up paying lawyers if you had to go through with it. So it makes sense for you to just pay them the money, because at least you get the certainty of it.
Right. So what you're saying is we should do the international mark based on the UK registration. Is that right?
Exactly. Yeah.
All right. Thank you. Thank you.
Great. Spencer?
Yeah, hi. Just a quick one, Oliver.
Yeah.
Where do you have to use the your R symbol? So when you're registered, are you meant to actually use that anywhere to show that it's
Yeah,
registered?
put it on the top right-hand corner of the trademark, just so people can see that your trademark has been protected and they can see exactly what has been protected. So, it's usually common. It has to be, you know, in direct proximity, usually on the right-hand side to the graphical
Yeah, but
representation.
but then when you're using it on your website, on your full composite logo mark, you haven't got the R showing on it. But then I notice in the start of your video, you do have the R shown. So where do you have to display
Okay.
that to show that you're registered and using it, or is just
You
using the
don't have
logos and the
to.
words?
You don't have to, but it does.
Right.
It will ward people off against. People will think twice about copying your brand. But I guess sometimes having that R symbol there is a nightmare for a designer,
Mm,
basically, because it just ruins their whole
yeah.
design project. Because now they have to put this stamp somewhere and ruin their artistic creation.
Mm,
So it depends. I mean, we're a firm of trademark attorneys, so I would hope that just by virtue of our name being Trademark Wizards, people would just
yeah.
obviously not
So
want to mess.
you would
Um,
suggest that just sort of put it somewhere uh, prominent
yeah,
once, if you like, but you don't have to just keep using it
yeah.
all the time. But yeah, okay,
No, it's good to do it.
yeah,
But, it's good to do it, but it's not compulsory. But I do
yeah,
tell, I do advise people to do it, because it just there's stigma behind it. I mean,
hmm,
subconsciously you would just say, actually, I'm not going to copy that brand
yeah,
because they've got an R in a circle next to their name, and
got it.
people don't register trademarks just for the aesthetic pleasure of having
No,
an R in a circle there. They do
yeah,
it because they're serious about their brand and their reputation.
yeah, okay, thanks for that.
Yeah.
Very interesting. Nick?
Yeah, hi there.
I
I would be interested just to see if you could put my company name in there because we have registered in the UK.
Okay, go on.
It's Adeus, Adeus, which is a Portuguese word. We registered in the UK. There was already an existing German trademark for a
What?
subsidiary of Allianz. So
Okay.
that's us there. So we're at the top, Mankind
So
Technologies.
if I search it by application date, then you can see when you filed the trademark. Obviously, you've got here. This is the Allianz subsidiary, but also
Yeah.
you're in different classes. Did you have a spat with them over class?
No. Well, actually, we applied and we never heard from them, and then we just got granted the trademark. So we expected them to get a bit mean about it, but we never heard from them.
Yep. Oh no, nice. No, it looks like it's gone through, and yeah, that's all good. I think your priority period has run out, but if you're only in the UK, then you don't need to worry about that.
Yeah, we're only in the UK. I mean, we do expect to go Commonwealth rather than Europe, so Singapore, Australia, South Africa, Canada. So for those ones, would they be separate trademarks for all of those, or is there one that would really reach across all of them?
Well, some of these, so there's something called the Madrid Protocol, and that governs the countries that are covered under the international registration system. So there are, maybe I can get it under here somewhere, Madrid Protocol countries. So you can choose from these countries. There's 113 members of the Madrid Protocol. They're usually the main. They're usually the main key markets around the world. So these would be able to be covered by the international registration system. But South Africa's not on here. What ones did you have? South Africa's not on here. So you would have
Canada, Singapore probably a
Yeah,
priority.
Canada's on there, Singapore's on there. A lot of the GCC states are not on there, Middle East states, because they haven't, they're not signatories to the agreement. But you know, you do have the UAE, which has just recently joined now. You can, yeah, they've when did they join? 2021 they joined. So people are joining slowly from the GCC and Middle East. But yeah, have a look at these. Have a look at these key markets here. It's Madrid Protocol territories. All right.
Okay, that's helpful. Thank you.
Anyone else with any questions? Good.
You can
Well,
always send an email in or give us a ring. I'm
great.
always about to talk
Thank you.
about trademarks.
Just wanted to add some of my own questions if that's right.
Yeah.
When you were talking about dissimilar goods, and what were you meaning by that?
So if in order for there to be confusion, goods have to be related. Okay. So they could either be the nature of the goods could be similar, they could be complementary, they could be in competition with each other, they could be on the same shelves in supermarkets, etc. So there would always be there would be a likelihood of confusion if goods are related, but or they could be commonly manufactured by the same people. So if um, you sell clothes and someone else sells handbags using your brand, those goods are related, okay, because they're in the fashion industry. But if you sell clothes and someone sells dog food using the same brand, those goods are not related because they're not commonly produced by the same manufacturers, and they usually have different distribution channels. So what you would then do is you would need to prove, if you could prove your brand has a reputation, then you would be able to say, even though there won't be confusion, okay, that company is taking unfair advantage of my reputation, okay, because of the use I've made of it. Or they could say that actually the use of that mark is detrimental to the distinctive character and the repute of my brand. So obviously, we sometimes have things like people have medical practices, for example, and then one of my clients or another company would want to sell sort of sex toys using the same brand, and even though they'll never be confused, what you don't want is someone looking for your doctor's surgery on Harley Street and then finding pictures what have no place of being displayed when someone's looking for your brand.
I see, I see.
Yeah.
Great. And if someone, well, if you file a trademark, and someone else has sort of, um, well, made your business in the thing, what, so you could either like find them sort of, or you wouldn't be able to like claim the business, for example,
Well, you would get them to stop
get them to stop. Okay.
using the. You would be able to get them to stop using the brand, and
Hmm.
you would be able to take the profits that they've made,
Wow.
or damages if everyone's in that situation. Everyone says we haven't made a profit, and then so we would calculate it as damages, which would be what you would consider to be a reasonable a licensing fee,
Sure.
had you given them a license to use the brand.
Wow. And you listed many large companies like McDonald's,
Yeah.
which you won against for abuse. Like, what was that? What do you mean?
So, I mean, the decision has already come out,
Mm,
and the appeal decisions already come out. So, I think my client had a trademark applied for a trademark for clothing
mm,
for Living It and Loving It, which is their brand.
mm,
And McDonald's have a slogan called "I'm loving it." So they
mm,
attacked our trademark application on that basis. to say that, you know, people would be taking unfair advantage of them, but ultimately, we cancelled all of the trademarks, all of McDonald's trademarks for I'm loving it, and we
Wow.
made them surrender a lot of the goods and services, and in the end, our client got their trademark. So yeah,
Wow, well done.
you'll be reading about that one soon.
Amazing, amazing.
Yeah.
Looking forward to it. Well, if no one has any more questions, I'm sure, well, we all enjoyed it. Thank you
Thank
very
you.
much,
I hope
Oliver.
so.
And you'll be receiving a lot of love on social media and all of that. But thank you very much from us.
Thank you. Thank
Oh,
you.
Nick asked if yeah, if we could get your details,
Yeah,
could you
of
send
course.
that over to us after?
Yeah, you can share everything. I'll get we'll do that straight after this.
That's lovely.
Share it with everyone. But thank you very much, everyone. I really appreciate the opportunity, and thanks so much
Thank you
for
for coming to
listening.
talk to us.
And I hope everyone has a good weekend. We're here.
Thank you, and
We're
you.
here.
Thanks.
Even though as an
Thanks,
entrepreneur,
Oliver.
and doesn't really mean anything, does it?
Yeah.
Thanks, Oliver.
Thank you.
Take care.
Thank you
See
very
ya.
much.
Thanks.
Thanks, Max.
Bye.
Take care.
Bye.